Welcome everyone to another video discussion of free answer writing program by Vajiram and Ravi. In this month we are going to see GS2. Today we are going to see topics of judiciary where we will see 3 questions. Let us see the overview of those 3 questions. The very first question is with respect to the evolution of collegium system. Over here we will trace the evolution and understand what are the potential reforms to make judiciary more transparent, accountable and inclusive. In the second question we will talk about the integrated judicial system of the nation and understand what is the constitutional distribution of power between Supreme Court and High Court. In the third question we will be talking about the Mediation Act of 2023. We will talk about the major provisions and we'll talk about the key issues involved with the Act. So this is the overview of the 3 questions. Let us start with the first question. Let's read the question together. Trace the evolution of the collegium system in India. Suggest some potential reforms to make the process of appointment in judiciary more transparent, accountable and inclusive. If you see the question, there are basically 2 major demands. The first is the evolution of the collegium system, which we will cater in the heading 1 of the body. Then we have to talk about certain potential reforms to make the process of appointment more transparent, accountable and inclusive. So this is going to be the heading 2 and this heading 1. In the introduction, you can briefly talk about the meaning of the collegium system and the current status. In the conclusion, you can talk about the balance between the judicial independence as well as what exactly needs to be there for the transparency and accountability. So let us start with the answer. As I said, in the introduction, you can briefly define the meaning of collegium system. Collegium system refers to a system of appointment of judiciary. Over here we have seen that through evolution we have figured out what exactly is the nature of it, as in what is the current status. Presently, Chief Justice of India along with the 4 senior most judge of Supreme Court, they form the collegium system in India. So that is there for the introduction. Let us start with the body aspect. In the body, in the heading 1, as the major demand is to talk about the evolution of collegium system, we will talk about the evolution of collegium system. The very first case we can refer over here is the first judge case, SP Gupta case of 1981. Over here we witnessed that through the judgment it was realized that the consultation and judicial appointment of the judges was not required, as in the exchange of views versus concurrence was understood, as in president, as in the executive can bypass the judiciary and appoint the judges. In the second case, which is Supreme Court Advocates on Record Association versus Union of India 1993, which is called second judge case. Over here, the definition of consultation was altered, where the Chief Justice of India's advice was binding on the President. And there was also mention with consultation of 2 senior colleagues, as in the judges of the Supreme Court. The third judge case, which is 1998 case, which expanded this idea of collegium and consultation of plurality of judges, where collegium of 4 senior most judges were to be consulted, and it talked about that in case if there is any adverse opinion or recommendation by any of the 2 judges, then the recommendation must be avoided. Then we came to the 4th judge case, which is 2015, based on the National Judicial Appointment Commission Act 2014. Over here, the Act tried to replace the collegium system, but the judicial case declared it unconstitutional because it was against the judicial autonomy. So basically, we have seen that as per the 3rd judge case, the collegium system is now reflected for the appointment of judiciary in India. So that is all for the evolution of collegium system. Let us move on to the second demand, which is basically the potential reform in collegium system to make it more transparent, accountable and inclusive. You can talk about that the procedure can be amended where executive also play a crucial role. Thus, there is a balance of executive and judicial representatives to ensure there are checks and balances in judges' appointment. The second, we can talk about expanding the criteria. The criteria which is mentioned in Constitution can be expanded to ensure that the process is inclusive in nature. So, the format can be expanded. The third is increasing diversity. We have seen that how the diversity factor, especially for the gender, is asymmetrical in nature. Thus, representation of women in judicial appointment must be realized. And fourth, increasing transparency. Over here, we are talking about whatever the collegium system and recommendations are there, the entire process must be transparent, as in the list of the candidate, the opinions, as well as the documentation and recording of the proceeding in minutes, to ensure the entire process is transparent and reflects the democratic value and setup of the nation. So that is all for the body that you can imbibe over here. Let us start with the conclusion. Conclusion, you can talk about way ahead, as in you can talk about that collegiate system definitely needs certain reforms. At the same time, there should be judicial independence. Also, along with those reforms, there should be certain elements of transparency to ensure accountability and inclusivity. So that is all for conclusion of the question number 1. Let us see the model answer and understand how can we inculcate the same in our answer writing practice. In the introduction, as I mentioned, you can define the collegium system. You can talk about what is the present status of the same. In the body part, as the first demand is evolution of collegium system, you can list down different case points and give what exactly was the recommendation over there. Then you can talk about certain reforms over here to ensure that the entire process is transparent, accountable and inclusive. And in the conclusion, you can talk about balance of judicial independence and transparency and accountability. So that is all for question number 1. Let's move to question number 2. Let's read the question number 2 together. Through the Constitution of India establishes an integrated judicial system with Supreme Court at the top, the High Courts are not subordinate to it. Discuss the constitutional distribution of powers between Supreme Court and High Courts in the light of Abu's statement. Over here, there are two major demands. Firstly, we have to talk about where we have integrated judicial system with Supreme Court at the top, but High Courts are not subordinate courts for the Supreme Court. So that is going to be the heading 1 over here. We are going to defend the statement and give proof points to ensure that the clarity with respect to this statement is realized. Then we have to talk about the constitutional distribution of power between Supreme Court and High Court. Now this will be the heading 2 of the body, where you can create a table and give a constitutional distribution idea in a comparative manner. So in the introduction, you can briefly talk about the integrated judiciary system. In the conclusion, you can cite certain case studies where we have seen that how High Courts are also constitutional courts. So let's start with the answer. In the introduction, we can briefly talk about integrated judicial system where the Supreme Court is at the top. Then we have High Court and District Court. You can draw certain diagrams to give a pictorial view of what exactly is the integrated judicial system. Then in the transition line, you can talk about that despite this kind of setup, the High Court is not a subordinate court for the Supreme Court. So that is again going to be your heading 1 after the transition, and you can list down 2 points why exactly the High Courts are not subordinate to the Supreme Court. Firstly, the impeachment process of the High Court is similar to the Supreme Court, that reflects that they both are equal in nature. Then we can talk about that the scope of writ jurisdiction of High Court is broader than Supreme Court, which is something we will explore in deep in the comparative analysis of constitutional distribution. So these are the 2 major points that you can imbibe for this heading of the body. Then coming to the heading 2, where we have to talk in depth about the constitutional distribution of powers of Supreme Court and High Court. Over here, you can do a comparative analysis. You can make a table. Firstly, you can talk about the original jurisdiction of the Supreme Court, which lies with regards to the conflict between union and the state or states or between 2 states, whereas the original jurisdiction of the High Court lies with respect to the conflicts between the state and the people. So that is something you can talk about original jurisdiction. With respect to appellate jurisdiction, Supreme Court has appellate jurisdiction for cases regarding to civil or criminal of High Court and the subordinate courts or the tribunal courts under the same. With respect to the High Court, they have the appellate jurisdiction with respect to the cases which are in the subordinate courts as well as the tribunal court of the state. With respect to the advisory jurisdiction of the Supreme Court, President can take advice from the Supreme Court with regard to any law, whereas we have supervisory jurisdiction for High Court, where they supervise the subordinate court and ensure that the entire process is integrated in nature. 4th point, you can talk about the scope of writ jurisdiction of Supreme Court, which is limited to Article 32, and that is limited to again fundamental rights. Over here, the High Court, the writ jurisdiction is derived from Article 226, which encompasses not just fundamental rights but also other legal aspects, other legal rights that a citizen is given. So that is all for writ jurisdiction of High Court. Then with respect to Supreme Court, they are the guardians of the Constitution, as in they are protector. They defend the constitutional values. And with respect to the High Court, they have control over subordinate courts to ensure, again, there is integrated judicial system in place. So that is all for the constitutional distribution of powers between the Supreme Court and High Court. Let us move on to the conclusion. Over here in the conclusion, you have the opportunity to talk about certain judicial cases such as Shankar Kumar Jha case. Over here, we have seen that how through the judgment it was understood that high courts are also constitutional courts, again, which is something we can talk about, that they are not the subordinate court despite the integrated judicial system that we have in place. So that is all for question number 2. Let us see the model answer and understand how can we inculcate the same in our answer writing practice. Firstly, you can talk about that how Indian judicial system is integrated in nature with a hierarchy with Supreme Court at the top, high courts below and subordinate courts. But we have to put a transition line where we can talk about that how high courts are not subordinate to the Supreme Court because of two major factors. Firstly, the impeachment process of the judges of High Court is in the same manner as for the Supreme Court. Then writ jurisdiction of High Court under 226 is wider than the writ jurisdiction of Supreme Court under Article 32. Then in the heading 2 of the body, where we have to talk about the constitutional distribution of power, you can talk about certain jurisdictions and list down a comparative analysis for Supreme Court as well as High Court. And in the conclusion, you can cite a specific judicial case to highlight that High Courts are also constitutional courts and are not subordinate to the Supreme Court. So that is all for question number 2. Let us move on to question number 3. Let's read the question together. What are the major provisions of the Mediation Act? Discuss the key issues involved with the Act. So this question is again based on current affair and straightforward. In this question, you have to firstly talk about the major provision of the recently passed Mediation Act, which we can talk in the heading 1 of the body. We also have to talk about the key issues, as in the gaps that the Act is not able to bridge. That will be in the heading 2 of the body. In the introduction, you can start with the brief idea what exactly is Mediation Act. You can also talk about mediation in brief, as in what exactly it is as an alternative dispute mechanism. In the conclusion, you can give certain points with respect to way ahead. So let us start with the answer. In the introduction, you can introduce Mediation Act. You can talk about that Mediation Act is recently passed to ensure that conflicts are resolved pre-litigation and through amicable manner. We have seen that how mediation is part of alternative dispute mechanisms. You can also talk about that there are various acts which have incorporated distinct sections just devoted to mediation, which reflects that the importance of mediation within the legal framework as envisaged by the government. So that is something which you can imbibe in the introduction of this kind of questions. In the body, in the heading 1, as the major demand is with respect to the provisions of Mediation Act, you can list down 4 to 5 provisions and expand them with ideas. Firstly, you can talk about that we have pre-litigation mediation requirement to settle civil or commercial disputes. Now, this is something which is kept as a mandatory attempt to ensure that the burden on the judiciary is in such a way managed that mediation comes as the first step. Then we also have certain limitation with respect to the time span. We have withdrawal after 2 sessions, and each session is supposed to be finished within 180 days, extended by another 180 days. So there are certain time constraints to ensure that the mediation is also in place, as well as the litigation that can happen after mediation is also in the fast track manner. Then we have the establishment of Mediation Council of India, which will register mediators as well as recognize service providers and institutions. This is kind of an institutionalization of mediation that we are looking, and through this kind of council, the mediation can get better legitimacy. The fourth point is there are certain areas of exclusion which is mentioned in the Act to ensure that certain steps, as in the litigation steps, can be directly approached and mediation can be bypassed, such as serious frauds, exclusion of environmental matter for NGT, and matter related to competition, telecom, security, etc. So these are the kind of points that we can see that there are certain areas of exclusion as well. So these are the major provisions for the Mediation Act of 2023. Now let us see what exactly are the key issues with respect to the Act, which you can imbibe in the heading 2 of the body. Firstly, we have seen that how there is mandatory pre-mediation litigation. Now, this kind of compulsory mediation can definitely expand the entire process of realizing the justice. At the same time, it can also become cost intensive for the parties. Then we have seen the formation of Mediation Council of India. Now over here it is a regulatory authority and there are certain aspects which would be subject to central government's approval. This shows that how certain provisions are captured by the executive and violates certain principles of separation of power. So this is something which you can talk about with respect to the formation of Mediation Council of India. Then we have seen shortage of skilled mediators, as in lack of adequate mediation expertise. Now this kind of lack can definitely impair the entire idea of mediation, as it might make sure the entire process is not as speedy as envisaged. Then we have issue with respect to international settlement, as we have lack of enforcement mechanism for settlement for international mediation outside of India. It definitely disincentivizes a lot of multinational companies to have India as a mediation center. Now this is something departure from Singapore Convention, which India has also signed. So that something reflects that needs to be bridged for this kind of mediation act. So that is all for the heading 2 of the body. Let us move on to the conclusion aspect, where you can give certain points with respect to way ahead. Over here you can talk about how exactly this kind of reforms, as in Mediation Act, as a proper legal tool, can provide comprehensive recognition to the mediation. You can also talk about that how, going ahead, there are certain reforms such as mediation should be promoted as a preferred and voluntary mode for securing justice, to ensure there is no mandatory kind of nature for the mediation. Then also we have to talk about law needs to be improved, because it may cause delay in administration of justice and raise the cost of litigation due to how exactly it is mandatory in nature. So these are the kind of points that you can imbibe for the conclusion, as in way ahead. Let us see the model answer and understand how can we inculcate the same in our answer writing practice. Firstly, in the introduction, you can talk about what exactly is the Mediation Act. In brief, you can talk about how exactly it is alternative dispute resolution mechanism. Then you can talk about the major provisions. You can list down the provisions with the proof points. Then, as the demand is also key issues, you can list down the issues with the proof point. And in the conclusion, you can talk about how exactly it brings a comprehensive framework where the pendency issue can be resolved. At the same time, you can talk about certain reforms which can be imbibed, such as voluntary in nature. At the same time, there needs to be certain reforms to ensure that the cost is also minimized. So these are the kind of points that you can imbibe for question number 3. So that's it for all the questions for today. Keep writing and thank you so much.